Hello everyone, my name is Sanya Mahajan. I am a legal intern in LEXCLIQ company, and today's topic of mine is remedies for breach of contract. When a person promise or agreement is done between the two parties but it is not completed or it is broken by another person, then we call it as a breach of contract. So, if a person causes a breach of contract, then another person who is party to the contract has the following remedies in order to complete his contract as per the circumstances. And firstly, there is a specific performance of contract and injunction order. In certain cases, the court has the jurisdiction to pass an order of specific performance and injunction order in order to prevent the breach of contract under the Specific Relief Act 1963. Another remedy is here, that is the quantum merit. The meaning of the quantum merit is payment of a reasonable remuneration for the work done. As per the general rule is that if any person promises to do any work or service for money, then such circumstances without completing that work or service, they cannot demand for such money. The principle of quantum merit is the exception to the general rule. The claim on the basis of quantum merit may be made in many conditions, that are when a party of a contract causes breach of contract for prevents the other party from performing his promise. Or second condition is that in the condition of void agreement, then also a person can ask for a payment, and when the contract becomes void or defective. The remedy for the breach of contract is the damages. When party commits a breach of contract, then another party may realize compensation for the loss and the damages arising to him by such breach. Provision relating to the damages are, that is under section 73, clearly states that party who has suffered since the other party has broken promises can claim compensation for loss or damages which is caused to them in the normal course of business. Such damages will not be payable if the loss is abnormal in nature, not in the ordinary course of business. And there are two types of damages, that is liquidated damages and unliquidated damages. Liquidated damages, sometimes the parties to the contract will agree to amount for the payment on the breach of contract. The unliquidated damages amount to payable due to the breach of contract is assessed by the court or any appropriate authorities. Rules regarding award of damages are here: compensation, not penalty, and limited damages are to be paid. Damages are attributable losses, mitigation of losses. Secondly, damage in case of the contract or a sale of goods. Then stipulation for the liquidated damages or penalty, cost of suit. As per the, then only the damages can be given as per the cost. Then after this injunction order is basically there is a decree for a specific performance of contract but for a negative contract. An injunction is a court order restraining a person from doing a particular act, so court may grant an injunction order in order to stop another. Last not the least, there is a remedy, that is the rescission of contract. That is when one of the parties to the contract does not fulfill his obligation, then the other party can rescind the contract or refuse the performance of the obligation. Then hence the conclusion is here that with this we come to know that party committing breach of contract are a guilty party and the other party is called as the injured party, that is the aggrieved party, and thus have the remedies as per law under contract. So guys, this was all about the remedies under the contract related to the breach of contract, and thus if you need any information related to it, please do write in a comment section, and please do subscribe this channel LEXCLIQ.